Good morning and welcome everyone to the National Policy Memorandum training. This training is regarding the streamlining of rights-of-way and business lease application processes for federally funded tribal broadband infrastructure projects. Some housekeeping rules before we jump into today's meeting. This session will be recorded. Recordings will be available on the Division of Real Estate Services SharePoint site, as well as BIA's website after today's training session. This training is not for media coverage. If you are a member of the press, please drop off this training now. If you have any questions during today's session, you can go ahead and put your question in the chat, and we will address all questions at the end of today's session. Also, a copy of the NPM that we will be going over for today's training is available at the following website. You can pull that up and have that available, and we will be going through the NPM for today's training session. The agenda for today's training is to discuss the National Policy Memorandum, National Policy Memorandum TRUS-44 A2. That is the policy that I just read through. We will go through a summary of the policies and procedures regarding this National Policy Memorandum, as well as federal broadband funding. We'll also introduce our new Office of Indigenous Connectivity and the new director. And we will also have a short session on NEPA for permit as well. Our presenters for today come from the Office of Trust Services, Division of Real Estate Services. We have myself, Carla Clark. I'm the Division Chief for the Division of Real Estate Services out of BIA Central Office. We also have Susan Brave, who is our Senior Realty Specialist out of the Division of Real Estate Services. We have Danae Wilson, who is the new Director out of the Office of Indigenous Connectivity and Technology. We also have Miss Justine Vivai on as well. She is our Environmental Protection Specialist and NEPA Coordinator at the Division of Environmental, Cultural, and Resource Management. And today we also have on our Division of Indian Affairs, Office of the Solicitor, Stephen Simpson, a Senior Attorney Advisor, and Ms. Lauren DiFilippo, who is also a Senior Attorney Advisor. We're going to go ahead and jump into the training. This is going to be presented, the National Policy Memorandum section is going to be presented by the Office of Trust Services, Division of Real Estate Central Office. So the purpose and goal of this National Policy Memorandum and training for today and next week was that the department wanted to issue a policy for efficient and effective processing of right-of-ways and business leases associated with federally funded projects that are available for tribal broadband infrastructure. The goal was to have consistent right-of-way and business lease application processes nationwide across BIA's regions and agencies, including our contract and compact tribes. The purpose of the National Policy Memorandum was to have a comprehensive policy framework around the right-of-ways and business lease processes. It also to provide guidance regarding activities of infrastructure projects and work in collaboration with the various partnerships that we have with tribal nations, with our federal partners, with industry, and also down to our BIA field offices. We want to make sure that we work in collaboration and partnership to increase coordination, foster those working relationships, and make sure that we're having those conversations to streamline, enhance processing. One of the other things that we also hope is that these changes to existing right-of-way grants, amendments, or if needing a new right-of-way, the conversations are happening early in the application processes between the grantee and the grantor. We're also going to discuss projects crossing 100% of tribally trust lands under 25 CFR section 169.4. This National Policy Memorandum applies to all BIA program offices, regions involved in the right and business lease processes. One of the scopes and one of the main processes that we wanted to identify in this policy memorandum is that if an application is received by BIA, that the review takes place within 5 business days as to whether or not the application is complete. And we wanted this, again, to be across the board, as we have many tribes that have entered into contract compacts with BIA to carry out realty and LTRO functions. So this NPM will be implemented nationwide. Okay, with that, I'm going to turn over the presentation now to Ms. Susan Brave, and she will get into the heart of the NPM. Thank you.
Good morning, everyone. I'm not sure if I have my camera on, but I'm not sure whether or not people can see me, but I'm going to turn it off. Thank you so much for attending. You know, these are exciting times for building infrastructure, especially in with all the federal funding available for tribes. Infrastructure is so important in many tribal communities where broadband access is new. Broadband projects are far-reaching. That allows high quality and quick access to information, education, and training for your workforce, and the delivery of healthcare services. So we recognize the pressure that some of the project management teams have working on these types of projects. So we're hoping that the NPM demonstrates BI support of the ongoing tribal infrastructure projects. In providing this information, it's a reminder of our regulations that can assist you in the planning of your infrastructure projects. So let's get started. Excuse me. For rights-of-way and business lease applications, where percent of the tribal, I'm having difficulties seeing the slides. There's a panel that's showing up, so it's kind of difficult to look at. I'm going to try to get it out of my view so I can see the whole presentation. So, all right. So for rights-of-way and business lease applications where the tribe owns 100% of the tract, no BIA approval is needed if the tribe or tribal entity is the applicant. And you can see 169.4 Part B, paragraph 1, and 164 Part B3 and 162 paragraph A1. A right-of-way or a lease is not needed if the applicant has entered into a contract that encumbers tribal land, and that's covered under 25 USC 81. No right-of-way is needed for service line agreements, especially specifically defined in the regulations. For leases, an independent legal entity owned and operated by the tribe may have to obtain a lease from owners before taking possession of the land. A lease is not needed to possess Indian lands if the applicant is a 25 USC 5124 corporation that manages tribal land directly under a federal charter or a tribal authorization. If the applicant is a third party, including but not limited to a tribal consortium or another federal agency, the tribe may exercise all of the regulatory permissions, including negotiating any payment amount and asking the secretary to waive the valuation, bond, and insurance requirements. For rights-of-way crossing multiple tribal lands, the applicant must obtain tribal consent from each tribe whose land the right-of-way will be crossing in the form of a tribal authorization or written agreement with the tribe. The consent document may impose restrictions and conditions that may become the conditions and restrictions of the grant. The right-of-way grant could be utilized as one grant for all tracts traversing by that right-of-way. Next slide. A decision on a lease or a right-of-way application may occur 60 days after determining that the application is complete. The right-of-way, tribal authorization, grant or lease, map of definite location, and any tribal use agreements connected to that tribal infrastructure project may be filed or must be filed with LTRO in 30 days. Section B of the NPM, the right-of-way and business lease applications for allotted lands. If an applicant is a third party, including but not limited to a tribe or tribal utility or tribal consortium or federal agency needs BI approval, the individual Indian landowners may negotiate for any payment amount and may waive the valuation requirement. The right-of-way crossing allotted lands may be approved for a negotiated amount under 169 and business leases under 25 CFR 162. BI will determine the number of owners of undivided interest, and that is usually in the form of a title status report for the purposes of calculating requisite consent based on BI records on the date of the application is submitted to BIA. If the tribe already owns the majority of the interest, consent of the other fractionated owners is not required, but the tribe must notify the co-owners in writing. Because the regulatory time change for timelines for approval, review of the application will immediately upon making the determination that the application is complete. And for some of the applicants that are new to BIA's regulations, hopefully this NPM will provide all of the guidance that they need to submit their applications. Next slide. Section C, rights of way applications crossing multiple tracks. The applicant can submit one right-of-way application for multiple contiguous tracks if applicable. BIA will issue one grant for all of the tracks traversed by the right-of-way for the infrastructure project if applicable. Section D, maintenance. The right-of-way use, including the right to access the right-of-way to manage vegetation, inspect, maintain and repair equipment, and conduct other activities that are necessary to maintain that right-of-way infrastructure project. Applicants may refer to a request to change technology, say like from an underground copper telephone line to an underground fiber optic line as a maintenance activity. However, under 25 CFR 127C, it identifies that this is an example of a new right-of-way that is within the same scope as the original right-of-way and not a maintenance activity. Section E, new rights-of-way use within or overlapping an existing right-of-way. Grantees may use all or a portion of that existing right-of-way for the use not specified in the original grant only if the same scope of use in the original grant of the existing right-of-way. Next slide. If the grantee proposes to use all or a portion of an existing right-of-way for a use not specified and not within the same scope of the original right-of-way, and the new use will not require grounds disturbance, the grant must request, and I think that should have been grantee must request an amendment to the existing rights-of-way. If a grantee proposes to use all or a portion of the existing right-of-way for a use not specified and not within that same scope of the original right-of-way, and then a new use will require ground disturbance, the grantee must submit a new right-of-way application. Applicants that are not the grantee of the right-of-way may need an assignment of an existing right-of-way or a new right-of-way. In accordance to 25 CFR 128, BIA may grant a new right-of-way within or overlapping an existing right-of-way if the applicant follows the procedures and requirements to obtain a new right-of-way, and the right-of-way does not interfere with the purpose of the existing right-of-way, and the applicant has obtained the consent of the existing right-of-way grantee. The existing right-of-way grantee may not unreasonably withhold consent. Next slide. If the grantee proposes to use all or a portion of that existing right-of-way for a use not specified and not within that same scope of the original right-of-way, the new use will not require ground disturbance. The grantee must request an amendment to the existing right-of-way. Another scenario is if a grantee proposes to use or a portion of the existing right-of-way for a use not specified and not within the same use of the original right-of-way, the new use will require ground disturbance. The grantee must request a new right-of-way. Applicants that are not the grantee of the right-of-way may need an assignment of an existing right-of-way or a new right-of-way. In accordance to 25 CFR 128, BIA may grant a new right-of-way within or overlapping an existing right-of-way if the applicant follows the procedures and requirement to obtain a new right-of-way, and B, the right-of-way does not interfere with the use or the purpose of the existing right-of-way, and the applicant has obtained the consent of the existing right-of-way grantee. The existing right-of-way grantee may not unreasonably withhold consent. Next slide. Section F. If an amendment changes the scope of the original right-of-way and that new use requires ground disturbance, the grantee will need to submit a new right-of-way application. If the amendment changes the scope of that original right-of-way and that new use will not require any ground disturbance, it can be reviewed and processed. Review and verify any amendments requiring compliance with the consent requirements under 25 CFR 169. Assignments. If an assignment is a result of a corporate merger, acquisition, or transfer by operation of law, then the assignee is excluded from these requirements, except that the assignee needs to provide the original copy of the assignment for recording. And it must be recorded within 30 days. The grant of easement or tribal resolution should be reviewed to identify if an assignment still requires consent, even if it meets the corporate merger, acquisition, or transfer by operation of law regulatory criteria. Next slide. G. Review the original right-of-way for express assigned language and applicability. Identify if the existing right-of-way language expressly states, directly or distinctively stated that the grantee can assign the grant and under what conditions. If the existing language does not contain such language, the approval of the assignment must follow the regulations. Verify that all grantee and assignment has complied with the conditions of the grant, provided the BIA with the notice of any violations, if any, submit a new bond, obtain landowner's consent, and comply with any possible compensation requirements prior to BI approval and recording. Next slide. Partial assignments. The realty staff will review the purpose of the partial assignment and will make a determine if the right-of-way should be submitted. A partial assignment may be used to authorize another third party to utilize an existing approved grant of easement under certain conditions. A partial assignment of a right-of-way will be reviewed and processed using the same assignment procedures discussed above. Review if the partial assignment purpose / use is consistent with the original grant of the easement's purpose and use. If it's identified that the partial assignment's purpose is different and requires any ground disturbance, realty staff will notify the assignee to obtain a new right-of-way. Review of the grant of easement to identify any conditions or obligations that reoccur, such as payments, and if applicable, ensure that that partial assignment addresses if the assignee or grantee or assignee is the responsible party. We also need to confirm that that partial assignment of that right-of-way adequately identifies the segment of the right-of-way that is to be assigned for recordation purposes. Next slide. Providing copies of rights-of-way and lease documents. And this comes up often. It is important to verify the purpose of the original grant through examination of the original documents to confirm existing grant stipulations regarding amendments or assignments. Grants for rights-of-way approved under 169 are provided to applicants. Therefore, applicants who operate and maintain those rights-of-way should have original grants of rights-of-way. However, agencies may discover that current holders of rights-of-way may have difficulty referencing approved rights-of-way for the Bureau to identify and to provide guidance on. And this usually happens when some of the original rights-of-way go back 30 plus years. So it's important for to retain, and especially for landowners, because some of the rights-of-way are long-term contracts. If the BI's reasonable search of existing rights-of-way yield no records, and the applicant is unable to also provide proof on an existing right-of-way approved under 169, the applicant may need to make a new application for that right-of-way. Tribes and individual landowners may request copies of rights-of-way that cross the lands that they have an ownership interest in. Companies or third parties requesting copies of rights-of-way or leases may need to be directed to make a request under the Freedom of Information Act where appropriate. A lot of our records have been archived to AIR, the American Indian Repository, and it does take time to retrieve some of those records. Next slide. Some of the key elements of rights-of-way and business lease applications, especially for those folks that are not familiar with BI's processing of rights-of-way and business lease applications. You know, land status, and you want to make sure that whatever that right-of-way and wherever it is being constructed, that the land status is very important, because we have restricted fee, we have individual Indian-owned trust lands, we have multiple status of both tribal, allotted, and fee lands interests. holders. Ownership is another key element to knowing exactly who you need to request consent on. Mixed owners of tribal and allotted lands, which lands are owned 100% by the tribe. Some tracts are still 100% owned by individual landowners. And then there's that mixture of both trust and allotted and fee land interests. And of course, BI does not include fee ownership in any of our transactions. So that is up to the applicant to retrieve consents on their own. BIA will provide information on allotted lands for the applicants to get in contact with. Contracts and the for rights of way and leases, complete rights of way and business applications for new rights of way, existing contracts, amendments, and assignments. All of those, especially for existing rights of way and business leases, are important in knowing whether or not you need to get another consent, including if there is an existing right of way. Approvals. Rights of way and business lease applications. There are some rights of way that do require BI approval, but they're especially the lands that project will be covering. No BI approval, as we just went through, is required. No BI approval is required for tribal trusts, tribal authorizations, or service line agreements. And that was since 2015, when the new rights of way regulations went into the effect. We used to also do revocable use permits. We no longer approve those as well. LTRO recording. All rights of way and business lease applications and the documents need to be recorded. Tribal authorizations and the required documents for those tribal authorizations need to be recorded in LTRO. Service line agreements also need to be recorded in LTRO. Next slide. And these are some of the funding, the federal funding, the historic lifetime funding available for tribal infrastructure projects. We've got the tribal broadband connectivity that comes out of the National Telecommunication and Information Administration, and the tribal broadband adoption and use, the feasibility, deployment, all of those activities. There was $2 billion available for tribes to access funding for their project. It's, I think, the second round of the notice of funding opportunity ended last month. I think it was March 22nd. And if I have that information correctly, I think there was 160 tribal applications that were received. We're kind of excited to hear all the new tribal infrastructure projects that are going to be coming under the tribal broadband connectivity program. The other NTIA program is the BEAD program, which was funding to state broadband offices for their project. And it's usually middle mile fiber optic projects. 42 billion went out to the states. Tribes were eligible to participate in that funding, but it would be partnering with state offices in order to be a partner in receiving some of those fundings as well. And I think the tribe then becomes a sub-grantee. The Infrastructure Investment and Jobs Act that provided an additional $1 billion to tribal broadband projects. That funding is comes up to about 13 billion. And then we have the Inflation Reduction Act for renewable air and water infrastructure. Those are coming and available to tribes in loans and grants, contracts, cooperative agreements, and that comes out, and it's probably more than 720 million. But that just shows you the historic funding that's available for tribes. And since this training is for our staff, our field staff all across the country, that these projects are going to be a part of, in one way or the other, a part of our review process. It may be a part of the recording in the LTRO, but it's just, as I said earlier from the beginning, it's exciting times for building infrastructure. Next slide. And this is a map of all BIA regional offices. It's kind of, you can't see that, but as you can tell, it's a very helpful map, especially for some of these projects that are going to be going from one region to another. And that concludes my portion of the NPM-TRUS-44 A2. Thank you so much. And I don't know if I think I saw lots of chats and lots of questions. So I'm not sure if we should entertain those now or wait to the very end.
Yes, thank you, Susan, so much. So we are going to take all of the questions at the end of the session just to make sure that we get through all of the appropriate content for today. And then I do want to just stress that, we shared the regional map and the link for the regions as the agencies and the regions and those tribes that are contract compact will be the first line of applications and questions regarding this NPM, or the submittals and submissions of the applications for the right-of-ways. So we wanted to provide this information to you all and make sure that this was available. If there are any direct questions, that those can be fielded initially with the local agency and regional offices. And thank you, Susan. We really appreciate the presentation and going through the NPM. The next slide, the next presenter that we have is Ms. Danae Wilson. Ms. Danae is the new director of the Office of the Indigenous Connectivity and Technology. So I'm going to go ahead and turn it over to Danae.
Hello and welcome everybody. I'm so excited to see y'all here, and I'm really surprised and I'm thankful for the amount of individuals who responded to the call for the training. I think it demonstrates how important this topic is and how it impacts everything that we do. So right before I came to this position, I was working at the Office of Science and Technology Policy at the White House. And prior to that, I was working for the Nez Perce tribe and tribes across the United States doing broadband deployments. And so I'm really excited to be here. And I think that this NPM really demonstrates what it will take to deploy these networks moving forward into Indian country. And it also helps identify some of the things that will be necessary for anybody applying for these rights of way. Thinking about what this may look like, very recently, USDA, who also has a ton of telecommunication and broadband funding that's going out the door, and are historically have been the broadband funders, our telecommunication funders, before this historic investment by NTIA. So when we think about what that looks like, those deadlines from USDA for Reconnect 5, as an example, they're very, very tight deadlines. And we want to make sure that we're prepared and able to help coordinate and provide the data that's required within those timelines. Some of those deadlines can be 30 days and they can be 60 days if the tribe is able to receive that funding. In order to ensure that we're able to meet those deadlines, collecting the most information upfront will definitely help. And so what I'm hopeful this position will do, and the new office that will be developing over the next few months, will be able to help coordinate what that looks like. If it's GIS for maps, sending out shape files, if it's coordination with our expansive realty team who are experts at making sure that the documentation is done, whatever it may be that we can do to help process and push these requests forward from tribes and from other government agencies to ensure that we're meeting those deadlines, we'd be happy to do. We will also be looking at, from the ICT office, what it will look like for spectrum allocations on tribal lands, and working through the various pillars for the strategies that will be developed in the National Spectrum Plan, which is underway now. We want to ensure that any of the information that's put out, that it's accurate, number one, and number two, that the representation of BIA is absolutely included in that plan. I'm very excited to be here, as I said before, and I really hope I'll drop my email in the chat. And if anybody has any questions specifically for me, or if there's anything that I can provide, any assistance that I can help with, please don't hesitate to reach out to me. Thank you. And thanks for having me, Carla.
Great. Thanks so much, Danae. We're so excited that your office is up and running. I know this is something that we've been really coordinating and excited to have, coming on soon. I know under, this administration, they've committed an all government approach to expanding high-speed internet to tribal communities. The historic funding is in the billions of dollars. This is just record-breaking funding amount for tribes. And so through our, administration and through the Department of Interior, this has been one of the highest priorities to ensure that we're fulfilling our trust responsibilities to tribes, increasing our government to government relationships, and making sure that, we have the resources available to advance self-determination and self-sufficiency out to tribes, to tribal homelands. So we are excited that you are on board, Danae, and we look forward to continuing to work with you in the future. Okay, the next presenter that we have up will be our Environmental and Cultural Resource Management section. And I'm going to turn it over to Ms. Justine Vaivai.
Hello, good morning, afternoon, everybody. My name is Justine Vaivai. I am with the Division of Environmental and Cultural Resources Management, and I'm going to give a basic NEPA presentation. And I know that we already have a lot of experts in our audience, but we do have a wide array of people who have a knowledge of NEPA. So I felt we could just give the basics, and we'll go from there. Next slide, please. So I'm with the Branch of Environmental Services. Our office is with the BIA Office of Trust Services, which is basically central office. We work with the regional offices across the country with NEPA-related issues. We also provide technical assistance on projects across the country as well. And our office currently consists of 2 NEPA coordinators and 1 NERDA expert. And we also have our cultural resource expert, that's Tamara Billy. She is our branch chief and also a supervisory archaeologist. And she was not able to attend the presentation today. She will be on the next call or meeting or training. Sorry. Next slide. So what is the National Environmental Policy Act? So basically, NEPA requires federal agencies to assess the environmental effects of their proposed actions prior to making those decisions. And the range of actions that are covered under NEPA is very broad. We can see a wide array of projects that we get questions on NEPA for. And I know the regional staff can advocate for that as well. It's a very complex, not complex, but it can include a wide range of projects. So using the NEPA process, agencies evaluate the environmental and related social and economic effects of their proposed actions. So this gives the opportunity for public review and comments on those evaluations that are completed for these projects. Next slide, please. So we just wanted to reiterate that reaching out to your region for NEPA coordination is very important, and that prior to beginning your project, we recommend you reach out and let them know that you are going to start a project or that you're thinking about starting a project, just so they know and that they're aware that you are going to start a NEPA document or that you need a NEPA document. In my experience at the region level, I feel like early coordination is key when starting the NEPA process. So in this slide, we always reiterate that we want you to reach out to your regional office and your regional NEPA coordinator or professional so they can help you get started on your project, or help you get started on your project, or give you advice or help if you need it. So that's what this slide is for. Next slide, please. So we have a QR code here. We did spend several months coordinating with the regions and also with internally to update our NEPA web pages. So these web pages have been updated. We have a lot of information on there. So if ever you get stuck or if you need more information on NEPA, this is where you can reach out or look and see what type of information there. We have the NEPA process, NEPA documents that are broken down there. So take a look when you get a chance. You can use your phone right now, and it'll direct you to that web page. Next slide, please. So when does NEPA apply? So NEPA applies whenever a federal agency proposes to take a quote, major federal action, unquote, that may significantly affect the quality of the human environment. So in this context, significant is an action that must be analyzed in several contexts with respect to the intensity or severity of its impact. And this is a very technical term of what a major action is, and that is something that drives the NEPA process. What is the BIA's major action that we're undertaking that requires NEPA? That's basically what the driving factor is. So next slide, please. So these are some federal actions that could trigger NEPA. Examples include financed or funded by BIA, approved or authorized by BIA, rights of ways, which we're talking about today, leases, residential leases, assisted / co-lead. So if we're doing a resource management plan amendment with BLM, that is an example that we have with Navajo region. We were a co-lead on that EIS and also regulated. And please note that this is not an all-inclusive list. So again, consultation is key. So reach out to your regional office. You can also reach out to us here at OTS. Next slide, please. So this little graphic just kind of illustrates how NEPA works. So we always think of NEPA as an umbrella. And under this umbrella, we have several different laws that we have to follow, which can include the Clean Air Act, Clean Water Act, National Historic Preservation Act, Endangered Species Act, and we say that these laws have their own requirements that need to be met. And this is not an all-inclusive list as well. There are several more that I'm pretty sure we can name off the top of our head that need to be met. And yeah, so this is a nice little graphic that gives, and then under NEPA, we have the documents, which is a CADEX and EA, EIS. Next slide, please. So these are slides for section 106. So the historic preservation law, the construction and infrastructure development that can harm cultural resources and can cause irreplaceable damage. So federal laws require the sites must be documented before clearance can be granted. And the historic preservation laws protect the past for the benefit of future generations. And this helps ensure tribal heritage and the connection to our ancestors continue. Next slide. So the National Historic Preservation Act, it was passed in 1966 and it is the most significant preservation law and mandates Section 106 review. This helps assure that agencies take into account the effects of historic properties of the projects they are proposing. So historic properties in this instance include standing structures, archaeological resources, traditional cultural properties, sacred sites, and those that are deemed eligible for the National Register of Historic Places. Next slide, please. So this is a nice little flow chart that shows the Section 106 process. We have initiating the Section 106 review, which includes scoping. We identify and document historic properties, which is information gathering. We assess adverse effects, which include information in the NEPA document, and then resolve adverse effects during public comment and consultation. So this is a nice little graphic that shows the process, and we have some additional text underneath as well. Okay, next slide. So NEPA and Section 106 of the National Historic Preservation Act. So again, even with Section 106, early coordination is key, and federal agencies are encouraged to coordinate compliance with Section 106 and the procedures in this part with any parts taken to meet the requirements of NEPA. So we just say the inclusion of historic preservation issues. Agency officials should ensure that the preparation of an EA and FONSI and an EIS and record of decision includes appropriate scoping, identification of historic properties, assessment of effects upon them, and consultation leading to resolution of any adverse effects. And the degree to which the action may adversely affect districts, sites, highways, structures, or objects listed in or eligible for listing in the National Register of Historic Places. So this just kind of outlines the process a little bit more. And I apologize, I am not a Section 106 or expert. That would be Tamara. So these are her slides. And if you have any questions, I can give you her contact information and she can help you out with more information. Next slide, please. Okay, and we just want to reiterate that we are here to help. If you have any questions about NEPA, or if you have any NEPA projects you currently have, we can always contact myself or Miles Lytle. He is our environmental protection specialist within OTS as well. And we also have Tamara Billy. She is our branch chief and supervisory archaeologist. And I think the next slide has our contact information. So I can drop our contact information in the chat as well. So that concludes our NEPA presentation, and we'll take questions at the end of the presentations. Thanks, Carla.
Great, thanks, Justine. Appreciate it. And that is the end of our overview of the National Policy Memorandum and NEPA. So we will go to the question and answer session. If you have questions, please go ahead and put them in the chat. I know we have a few in there right now. I'm going to turn it over to Naomi and Simone. If you could please go through the questions, how we have received them in the order. We will take those right now. Thanks, everyone.
Sure. Thank you. Thank you, Carla. This is Simone. I'll go ahead and address some of the questions in the chat. I think we'll go ahead and simplify it a little bit and start with the realty questions, and then we'll go to the questions for the NEPA staff. And when I'm done answering your question or refer it to the panel, I'll go ahead and put a little fist bump by your question. So the first question in the chat that we'll start off with is coming from Joy. And this refers to, I think, the slide 17 that we had up, and that was approvals in the graph. Please elaborate on the approval process on tribal trust authorizations or service line agreements. It states no BIA approval required in the graph. So Susan, on your graphic, you had the different, and I think on the very end, you had a flow line that discussed service line agreements and tribal authorization. So maybe describe that a little bit for this question.
Sure. Tribal authorizations. Well, let me just start off. When the new right-of-way regulations went into effect, there were certain transactions that were once required for BI approval, but since the new regulation changes, there were, I think I had mentioned, permitting, service line agreements, and tribal authorizations. Those are the three types of documents that do not require BI approval. I'm not sure how much detail more there. If you look at the regulations, and of course, this training is for the field staff, and of course, being familiar with the regulations, knowing what is required, what is not required for BI approval is an important part of the realty staff's responsibilities. So if you look at 169.4, it will go into who needs a right-of-way, who doesn't, what is needed for a tribal authorization, and what is not required for some of the other transactions like service line agreements. I'm not sure if I answered that question correctly, but Stephen, if you have something to add to it, well, I'd welcome your response.
Thanks, Susan. I was just going to jump in to say that the, as noted in the presentation, this for service line agreements, there are specific requirements for that. Most of that is actually a definition of what we mean by service line agreements, because when we were doing the 2015 regs, we got a lot of comments from industry trying to pull what we would consider distribution lines and other larger lines into service line agreements, because we said service line agreements don't require the BIA's approval. So we said, no, that's not what we're thinking about. And so we defined it very specifically, and that's not actually in the definition of definitions in the right-of-way regs. It is in the subpart that talks about service line agreements. So there are only certain types of lines that qualify for that. Basically, it is a small line that is going to serve one building. You know, it's the line that comes from the street to your house, basically, is what we're talking about, that kind of thing. And so, so that's important to check out. And there's some process there because we need to get, as Susan pointed out, we need to get copies of that and record them. There is a little bit of a NEPA piece there. You'll note if you look at the categorical exclusions in the departmental manual for BIA, you will see a categorical exclusion for service line agreements. Now that's rather odd because we just said service line agreements don't need BIA approval, and so they're not major federal actions and do not require NEPA review. Why is there a categorical exclusion for them? Because we haven't managed to get it out of the DM yet. Don't worry about it. But yes, tribal authorizations are kind of new as a result of the 2015 regs. And that process is largely up to the tribe as to the process for getting a tribal, for doing a tribal authorization. We just say that we need one from the tribe to record it. But that's basically it for those. That's all I had to add.
Okay, thank you, Susan and Stephen. So
Sure.
just to sum up the answer quickly, the approval process for a tribal authorization would be through that particular tribe. The service line agreement is generally an agreement between the authorized occupant and the service provider. And so the regulations just require filing with the BIA, and so those are not BIA approval. So just a little bit about that process, and Joy's acknowledging your response, Stephen, and she said that was very helpful. So thank you for that. So let me go, since we're on the topic of service line agreements right now. I know a lot of comments that we have in the chat are some discussions regarding NEPA and cultural requirements, and we'll defer to Justine right there. So I'll try to keep it in the line of service line agreements and right-of-ways. So one quick question that we have in the chat is coming from Tobiah. Is an easement different than a right-of-way?
No, a right-of-way is actually a species of easement. And the regulations are give you a good long list as to what kinds of documents come under those regulations, including various types of easements.
Perfect. Thank you, Stephen. Hope that was helpful for you, Tobiah. Another question that we got in the chat that was tending to a bit of a service line agreement question, just because of the services provided, but it's also tending to appraisal. So the question's coming from Leslie, and is how is it that a homeowner can use, and this was I think a question on our slide 17, I'm sorry, on slide 20, during Danae's presentation, and the question is, how is it that a homeowner can use federal funds to place a well or septic tank placed on their property without being required to have an appraisal done as required for the right-of-way to be placed on the property with funds from NTIA? So when I read this question, I initially thought some services like septic or water or well might be coming under a service line agreement, and some right-of-way decisions requiring for fiber might necessitate an appraisal. But I can read the question again, but you can see it for yourself in the chat panel. But how would you answer that?
Well, I didn't think, this is Susan, I didn't think that defined a service line agreement. Digging a well is ground disturbing, and it is not, or does not fit within the definition of a service line agreement. Stephen, do you have a response to that question as well?
It wouldn't, and neither would the septic tank. I think the key here is whether it requires an approval from the BIA, which if when you're putting in a line, a fiber line on your property or something like that, and I'm focusing on the BIA end. I don't know what funds from NTIA and federal fund. I'm not sure on the funding end of things, but on just the construction end of things, you need, and if you're putting the fiber line in, you probably need, unless it's a service line agreement, you probably need a right-of-way for that, because the secretary actually, under the statute, is granting an interest in the land. Okay, and therefore it requires the BIA's approval and all of that. But for a well or a septic tank, you're not doing that. You're just digging a hole and putting something in. Generally the homeowner is, or a contractor for the homeowner is. And so that doesn't require a grant of a right of way or an easement. So so it does not require approval from the BIA. Now, as Brian just put in the chat, you might be getting funds from a federal agency, like NTIA, like HUD or IHS, and that may require NEPA review, but probably not an appraisal. It depends upon how that all works, for their particular funding. But that's the answer from the BIA's point of view for that.
Excellent, Stephen. We got a couple more
Sure.
service line agreement questions, panels. One question from is, running new backbone lines to change from copper to fiber infrastructure, for example, would not qualify as allowed under a service line agreement?
Probably not, if I'm understanding what a backbone line is.
It's a change also in from copper to fiber.
Yeah, and copper to fiber is not a change in use, really.
Hope that
Ground
response
disturbance
was helpful. Right, requiring
Yeah.
ground disturbance.
Right. I
Okay.
mean, as the example that we use in the regulations, in the preamble to the regulations, is if you are, if you're changing from an underground copper line, or an overhead copper line to an underground fiber line, then you're going to have a new right of way for that, because you're actually changing the use of the land. If it is an underground copper line to an underground fiber line, that's not a change in use, and it's not a change in disturbance. So you probably could just amend the right of way probably for that, if we even think you need to do that. But if a backbone line, if that is it probably would not qualify or under a service line agreement, because my understanding is that would be to serve more than one house, more than one structure or building, and that's what actually the regulation doesn't say house, it says building, I think. But yes, that would not be a service. If it's bigger than that, it would not be a service line agreement. So it depends upon, whether it requires a new right of way or not depends upon the location of the lines. Basically, what you have to do to get the line in is what it boils down to.
All right,
Good.
thank you.
I'm glad that answers your question.
Excellent, thank you. And the other question we have is, I think you were touching on that a little bit, Susan, earlier, is does the service line agreement require a master right of way from which it branches off approved by BIA?
A service line agreement is for a service, utility service usually, to the house. if the, say if it's electric line and the pole is on the parcel, then yes, it needs a right of way. And the line going from the pole to the house is a service line.
Right.
So you
I hope
would
that
need that
answers.
approved. Yeah, the approved right away to branch off of, right? Okay.
Yes.
All right, perfect. I think that in the chat that summarizes some of the questions we have for realty. But let's go ahead and transition to some of the discussion and questions that we had in the chat for NEPA. And thank you, Brian, for clarifying your question. And I'll start with your clarified question. How does BIA staff evaluate existing right-of-ways for environmental NEPA compliance that were granted before the release of the National Environmental Policy Act of 1970? Is there input from DOI Solicitor's Office on potential IA liability if a categorical exclusion is used, and what supporting documentation is required for those CEs? Many existing right-of-ways were granted pre-NEPA. And then Brian just kind of acknowledging again that in Northwest, they have very old right-of-ways, none of which have NEPA documentation to review or evaluate. And so there was also a bit of discussion in the chat as well, regarding that existing right-of-way, if there was a modification or amendment to an existing right-of-way, if that would be considered a federal action, and that would require a new NEPA review. And then there was, I think, some citations also in the chat to BIA's IAM 59 IAM 3H with some information on that. So Justine, that's kind of a multi question for yourself. Do you have a response? Or Stephen too, because I think you were also being asked on what BIA would do if we were faced with a new decision on an existing right-of-way. That predated NEPA.
I would have to defer to Stephen on this question. I know this is something that's come up before, but we'd like to hear from Stephen.
I was going to ask you whether you wanted to take the lead, Justine. That's fine. I'll take it. For a right of way, yes, there are a whole lot of really old rights of way out there, and thank you, Brian, for bringing it to the fore. Yes, you do need to do NEPA review for it. What you would do, because as you put in the chat, the categorical exclusions for amendments to right-of-ways require that there is an existing NEPA analysis. And I will tell you from experience in another context that the department is very picky about that, and should be, about that existing NEPA analysis. And it's basically because you're doing something that you want to have a baseline for, and for that amendment or for that. You've already assessed those. Well, in this case, you haven't, because there is no baseline analysis. So that categorical exclusion would not apply because there is no existing NEPA analysis covering the right of way. And so you would have to do it. You would do an environmental assessment for it. And in fact, as you point out, any new right of way would not apply, would require NEA. And so the impacts of the existing right of way would be covered in your EA under affected environment. as part of the existing environment, the existing environmental impacts, and under your affected environment and under your as part of your cumulative impacts analysis for past projects. So yes, Harding, you're right. It would be considered a new federal action. I'm looking to see if there's anything. No, I think that was it. But I think, yes, this is a big problem out there, and there is a lot of it out there. And Tobias, the next, your question about your statement about new rights of way requiring an EA, unless they can be categorized as easements, there is no categorical exclusion for an easement either. So, you know, if you're doing a conservation easement or an avigation easement, those require NEPA review, require an EA also.
Okay, so I think
And I think that's the NEPA pieces, Simone.
okay, good deal.
Justine, have you got anything? Did I get anything wrong, or did you?
No,
Any idea?
no.
Any thoughts?
No, I think you took care of it. I think that was kind of the train of thought that we had as well. So
Okay, good.
yeah. Mm-hmm.
Right, perfect. And we got another question kind of embedded up here. I think it might have been asked when we were on slide 13, and it's from Brandon. And the question was, does this apply to rights of way before the ruling? I think there might have been, if maybe I caught the right slide. I know we were about this area. Brian, if I didn't capture your question on the appropriate slide, if you wouldn't mind adding your question again. And I'll go to your second question. Is there if there is no documentation for an existing right-of-way, but another entity uses that right-of-way as a reason for not getting an individual owner's permission, is that allowed?
I think I'm kind of confused by the question again. Can you read it again?
Sure. If there is no documentation for an existing right-of-way, but another entity uses that right-of-way as a reason for not getting an individual owner's permission, is that allowed? So maybe there's a use happening and they're saying, yeah, it's a little hard to understand.
Yeah, maybe you could clarify it. If there is an existing right of way, but no one can provide the proof, but someone wants to use it, is that?
Yeah, I think you're getting there.
I'm sorry, I didn't mean to laugh. I know that those are serious questions out in the field, and but I would be concerned. Stephen, do you have a?
Yep, I would be concerned too, Susan. You know, if we don't have documentation for it, and that entity wants us to, you know, is trying to rely on something that we have not seen, then they're running a risk of trespass.
Right, and it wouldn't probably be allowed. I mean, whether or not it was an old existing right of way that was vacated or has expired, but it wasn't remediated, I think there's some concerns there. But I would think if the applicant who wants to run a line that's within an already existing line, I think the field needs to do some research on that.
All right, good deal. So I guess Brandon, work with your local office, get some more information, and might need to seek some more guidance on that situation.
Mhm.
So hope that's helpful. And then we got a comment here from Leslie. For those that are very green in regards to right-of-ways and ground disturbance, etc., is there a beginner level training available? We have other staff that work in this realm, and we are interested in getting a better understanding to be able to assist more, but feel like we jumped into the deep end of the pool. Carla?
Hey, thanks, Simone. So right now we are planning a national realty training, tentatively scheduled to be held in June in Albuquerque. This training will be for BIA field staff and for contract compact staff that have realty functions. We are also inviting, our field staff in the areas of LTRO and probates, and then we will also be coordinating some of our federal partners for attendance, as well as our solicitor's office. We have been really busy trying to get our field office locations staffed up. I know that's been a concern, and we've been hearing that being addressed by our departmental leadership and our BIA leadership to get those vacancies filled across BIA. That is one of the highest priorities that we are working on. And so we wanted to offer this training today. This NPM training will be held next week as well as our national realty training, where we will be presenting, various topics in real estate services, as well as environmental. We're hoping that with the trainings that we're doing for agency and regions, that it can be conducted as a train the trainer. We'll conduct the trainings for our region and agency staff, and then hoping that the regions and agency staff can coordinate with tribes to do some additional trainings, providing question and answer sessions similar to what we're doing here, and then working with them to help streamline and improve these processes for this NPM. So that's the update that I have regarding training sessions. We do hope to host the national training in person as well as virtually. So those staff that are unable to travel, that they will be able to take a look at these recorded sessions, refer back to them, and then any new staff coming on to BIA will be able to utilize these training sessions as training opportunities. So if there is anything else, any other trainings coming up, we will post those on BIA web pages for tribes, for allottees, and we are really trying to get additional training mechanisms out to the field offices.
And that could probably include, I know we've talked a bit about having some virtual options as well. Carla will probably also keep that, but just acknowledging the comment if we have a virtual option available. I know we're kind of working on that. Okay.
Yes, you are correct. Thank you.
Okay, thank you, Carla. Let's see, one other question. I've got a couple more that came up. This one will go to you, Susan. We chatted this, so I put this in the chat for the group. The question is there any up-to-date guidance on how to encode in towns those service line agreements or tribally approved documents?
Yes, we just went through the right-of-way training this week with the contractor, CGI. And we did talk about service line agreements and how they are to be encoded. We did, the right-of-way user group are working on change requests, but one of the change requests is to actually get a code for, we already have a code for service line agreements in TAMS. We're working on a tribal authorization code, so as well as what type of a subtype, what that tribal authorization is. So we are working on those change requests. But yes, for right now, the service line agreements are in TAMS and there is a way to encode them. And I encourage anybody that, and of course, we just completed our right-of-way training. So I encourage anyone that needs additional information on how to encode either a service line agreement, a right-of-way, a tribal authorization, get in DOI Talent and sign up for the next training. Thank you.
All right,
I don't know
thank
if
you. Thank you, Susan. Yeah, no, I think you answered the question on the TAMs, on the business rules for that. Let's see, we got a couple quick comments, some questions that came in. One had to do with the date for the National Realty Training. So we're thinking that's the week of July 10th. And more information will be coming out officially on that. Anything else? Anybody? Sorry.
Simone, it's June.
June, sorry.
11th.
Thank you. June 11th. Thank you. Thank you for that. Okay, more questions coming in. Okay, thank you for that, Carla. The date was posted. Let's see, going to Ruth. Can you go over the steps for an existing right-of-way the third party is also using? That like an assignment, or can you go over the steps for an existing right-of-way that third party is also using? Maybe Ruth, you could provide a little bit. Would you guys need a little bit more information?
Yeah,
In the chat, maybe you can provide a little bit more information about that use, about what the decision might be. That would be
right.
helpful.
And who the third party.
And who the third party might be. Thank you, Ruth. And then we got a comment from Brian. NTIA really needs to understand the lack of BIA right-of-way NEPA documentation, evaluation on tribal lands, and keep in mind when they push out new CEs for us to adopt. As you know, a lot of deadlines are being pushed at BIA. I presume that existing capacity of BIA agency realty staff simply cannot meet these demands. They're really labor-intensive projects. So it was a comment for the group. I don't know, Justine, if you wanted to reply. Let's see, I'll go ahead and read another question. This question is coming from Paula. My question may be for the right-of-way user group, but can there ever be an email enhancement done or added in the TAM system to update or track owners with a current email address or a cell phone for a text notification? So when we do right-of-way or land lease or any other title encumbrance, the system can send a digital notification, and the TAM system would notify through email or text by sending a general message to each landowner. Yes, we do have, I think that's a good idea. Paula, if you can contact Susan on submitting those requirements to the user group. So I won't read the entire comment, but thank you for that. And I'll provide that to Susan. Susan, do you have anything to add?
Thank you.
On that?
And that's, we are working on several change requests in TAMs, but for the purpose of this NPM, we can have another discussion regarding TAMs. And TAMs is constantly evolving with all the new different types of requests for enhancements. But the regulation states that we need to provide a written notification to the landowner and the applicant that this that they have an applicant has submitted an intent for a right-of-way. So those need to be written documentations. Email and text, I don't think is an appropriate form of communication to our landowners.
Right.
That's just my opinion, but I think the regulations say it needs to be in a written form to the landowner or to the tribe if they're if an applicant wants to cross an allotted or tribal lands.
Okay, thank you for that, Susan. I think that concludes all the questions we have in the chat at the moment. I'll go over and turn it over back to Carla and the team, and thank you for all the questions.
Great. Thank you, Simone. Thank you to our panelists for today's session. A lot of information, really beneficial information on this training. I really appreciate and see all of the different individuals that we had on this training. Yes, please let everyone know that we will have another training session next Tuesday Those on today's session are always welcome to attend next week's session. You might think of something, after you were on today's training session. But again, this training is open to tribes, to our BIA field staff, to industry, to our federal partners. Help build these relationships, help to streamline these processes, and answer these, questions that you all have. I really appreciate the panelists' time. We have a great set of panelists here, worked very hard on these trainings and getting these questions asked for you all. Again, we are very excited to have Danae on board with her new office, helping to build those relationships and just to continue to further develop Indian country with broadband connectivity. So that is it for today's session. We appreciate everyone's time. Everyone, please have a safe and healthy weekend, and we may see you all again soon. Thank you so much. Have a good day, everyone.